Hey guys, welcome to this video. I'm doing this because yesterday afternoon, so that's Tuesday, July 16, the Centers for Medicare and Medicaid Services came out with their new rule on arbitration agreements and nursing homes, long-term care facilities. And I thought this was important enough, I wanted to do this video. Give you a little bit of background. A couple years ago, the rule came out that there would no longer be binding arbitration allowed in nursing homes. So if you take a loved one, it's a grandparent, a sibling, a parent, whoever it is, put them in a nursing home, they could not require you to do an arbitration agreement. And arbitration is where you have to go before one or usually three arbitrators, and there's no court, there's no jury, and you go before these arbitrators. And there's a reason the industry always wants that, because it tends to be much better for them. And so then we had a change of the administration, and then there was a reversal of that. They said, no, you can do binding arbitration. And now we have kind of a compromise. It's not everything that I want and other people who are representing elderly consumers who have been abused or injured in a nursing home want, but it's much better than it was. So this is, if you can see the domain here, federalregister.gov, and then this is what we're talking about here: revision requirements for long-term care facilities arbitration agreements. And this just came out, like I said, yesterday. So if we go to the PDF, and this will be the summary here, and then I'll kind of walk you through this document. It's 75 pages long. We're not going to go through all that. But the summary is, it says, we repeal the prohibition on the use of pre-dispute binding arbitration agreements. Okay, so that is a negative in my view, but they do make it so that that cannot be a requirement of admission. And so then we have kind of this background, and so it says October 4, 2016, among other things, had some requirements about binding arbitration. It prohibited long-term care facilities from entering into binding arbitration. And then we'll come down here. There was a lawsuit by basically the trade group for nursing homes. And so then the result of the court's decision, the government agency directed all these facilities not to enforce the final rule. And basically then they revisited this. So we reevaluated the procedures. And then 2 years ago, June 8, 2017, we're saying, hey, here's a revision. So the proposed rule would remove the provision prohibiting pre-dispute binding arbitration. And then we go down here and they talk about what exactly they were doing. And then they start talking about, here are all the comments that came in. And most of the comments were against binding arbitration. But obviously the industry was in favor of it. And this is worth reading, because they'll say, here's some general comments. Here's our response to it. But if we scroll down to the end, this will kind of cut to the chase and lay out exactly what they are allowing and what they're not allowing. So let me get to this. So for reasons set forth in the preamble, we're amending this as follows. And so it says, if a facility chooses to ask a resident or his or her representative, so a lot of times if you're going into a nursing home, mentally you're not the one making the decision. So it would be a family member, somebody with a power of attorney, a guardianship over you. And so that's what they mean by representative. So if a facility chooses to ask a resident or his representative enter into agreement, facility must comply with all the requirements. This is key. Facility must not require any resident or his or her representative to sign an agreement for binding arbitration as a condition of admission to, or as a requirement to continue to receive care at the facility. It must explicitly inform the resident or his representative of right not to sign the agreement as a condition to get in or to continue. Now, here's the significance of that. If you've ever been in a situation trying to get a loved one into a nursing home, you know that most of these places are very crowded and there's not a whole lot of choice. And you're trying to find one that's close by so you can visit your loved one. And then you also want it to be clean and you want it to have a good safety rating and all that type of stuff. Well, then when you finally find one that'll take your loved one, and this is always a very stressful situation, then they say, by the way, you have to agree to arbitration. Well, as a practical matter, you don't have a choice. You get okay. But now this is saying the facility will not be allowed to do that anymore. And if they say you have to agree to arbitration, then they're violating this law and you can take some action against them. So that's this first part. Second part, facility must ensure that the agreement is explained in a form and manner she understands. Resident or representative acknowledges they understand the agreement. And if there's an arbitrator, it has to be a neutral arbitrator. So in other words, the arbitration agreement, if you agree to it, cannot say, oh, by the way, the administrator of our nursing home will be the arbitrator, will be the judge on that. No, it's got to be a neutral arbitrator. It's got to be in a venue or a location that's convenient to both parties. And you have to have the right to rescind the agreement within 30 calendar days of signing it. So to rescind just means to tear it up. And so you would go in and tell the facility, hey, and tell them in writing, look, I rescind, I revoke that agreement on arbitration, and they have to let you know that you have the ability to do this and honor that when you do it. And then this part 4 down here explicitly state neither resident or representative is required to sign an agreement binding arbitration as a condition of admission or continuing to receive care. So again, they're just really stressing this idea that it's okay to do binding arbitration, but you have to be told directly, explicitly, that this is not a condition to get in, and it certainly is not a condition to stay. Because you could imagine they say, okay, yeah, you can get in without this. Then the next day they come to you and say, we're going to kick your mom out if you don't sign the arbitration. No, that would violate this law. And then subsection 5 may not contain any language that prohibits or discourages from communicating with federal, state, local officials. In other words, nothing in the agreement can say, we don't want you to report us to the state officials or the local officials or the federal government officials. They can't do that. And when the facility and resident resolve a dispute through arbitration, a copy of the signed agreement and final decision must be retained for 5 years. So this is so that the federal government can come in and look at these things. So there's more to it than this, and this has not, technically been published yet in what's called the Federal Registry, but this is what we expect it to be here in a couple days. And then usually this will kick in about 60 days. So if you are either right now looking for a facility or you anticipate you're going to be in the very near future, I would definitely check in on this, because my advice is to think very carefully before agreeing to pre-dispute binding arbitration. There is a reason that all the nursing homes want this, and it's not because it's in your best interest. Okay, if they all want it, that's probably a pretty good sign that that's not going to typically be good for you. So in any event, hope that this is helpful. I know it's kind of a different video, but I saw this come out. We've been watching this for a number of years, and wanted to let you know about this because there's so much abuse in nursing homes. And I'll just say this, not to get off on a long tangent, but when we've sued nursing homes, here's the argument they make. They go, John, did you know your client was in poor health? And yeah, maybe we abused them, maybe we neglected them, but if they had been in great shape, they would have been fine. And I go, are you serious? My client in a nursing home was in bad shape? Who could have ever thought of that? Well, obviously, if we're in a nursing home, we're in terrible shape, either mentally or physically or both. You don't go to a nursing home because you're an Olympic level athlete and you're like, I just want to hang out here for a few weeks. No, you're in a nursing home because you're in very bad shape. And so they always use these arguments like, well, it didn't matter that we let your mother get all these bed sores, or we, let infection run rampant. And then their other defense has been, well, you have to go to arbitration. So no jury will ever sit in judgment of us. And we're protected because we're going to get an arbitrator who's going to take care of us. Well, that's coming to an end here unless this rule changes, which I don't think it will. And I think what the government has done here is tried to strike a balance between the industry just desire is not even a strong enough word, just the massive hunger the industry has for pre-dispute binding arbitration. And then what advocates and consumers are saying, which is, look, this is unfair. We don't really have a choice. And so the government's saying they can't make you do it, but you are allowed to do it if you want to. And, in the grand scheme of things, this is better than what I was expecting. So if you're in Alabama, you have any questions about this, feel free to give us a call, 205-879-2447, or you can reach us through alabamaconsumer.com. I appreciate you watching this video, and I'll talk to you soon. Bye-bye.